In Lonoke County, Arkansas, a man rescued his daughter from a predator. He unalived that predator, and now he's running for sheriff. He's also facing second-degree unaliving charges, as well as an enhancement for the usage of a firearm in the commission of a felony for saving his daughter. I had the opportunity to sit down with the current sheriff, John Staley, and I had a 2-part interview with him that lasted almost 80 minutes total. I've broken that interview up into a 5-part series for you guys, so you can hear the exact position that the current sheriff is taking on all of this. What he basically attested to is the prosecution's position on all of this and why they are going after Aaron Spencer. And on top of that, I'm going to show you what the law actually says about self-defense and kidnapping, as well as the unbelievably lenient S-crime legislation that exists in Arkansas. If you live in Arkansas, I would be infuriated for your children. I would be scared for your children because their safety is seriously in question. Because if a predator travels to Arkansas, which according to John Staley has happened before, because they know that Arkansas is lacking strict statutes about S crimes against children, especially if they are over the age of 14, if they are 14 and older, it literally changes from rape and sexual assault and a multitude of other things to sexual indecency with a minor. That is legitimately what it changes to if they are 14 or older. So let's get to it as I start my interview with Sheriff John Staley, and make sure that you like, follow, comment your thoughts below. What do you think about their position? Because I think it is very important that we get both sides of the story. Both sides of the story. What is the current sheriff thinking? What is the current prosecutor thinking? And while the prosecutor failed to return my phone call, even though Sheriff John Staley said he wouldn't talk about the case, he said some pretty telling things. And I think it's important that the world hears exactly what their position is. It's Kristin.
Hello.
Hey, is this Sheriff Staley?
It is.
How are you?
I'm good. How are you?
I'm good. So, my editor wanted me to reach out. So I guess there was a conversation that you had with another source, or where you had made a comment that in the Aaron Spencer case, there actually wasn't a kidnapping.
I can't go into detail about any of that, and I don't know what source that was, but there was a kidnapping. There was not a kidnapping. You could call the prosecutor about that, but there was no kidnapping. So it doesn't mean that this was not a horrible situation, but there's going to be more. I can send you audio. I recorded a statement, and I've also got a written statement, but I can't speak on the case itself.
Sure.
Now, I've been asked about him running for sheriff. I can respond to that with what I responded with everybody else, and I can send you that. I can shoot that to you in a text, or if you give me your email, I can have it forwarded in an email. But I don't know who the source was, but I can tell you there was no kidnapping. The prosecutor can confirm there was no kidnapping, but I can't go into details about the case.
But I guess the resounding question I think the public kind of has is, is that everybody keeps saying, or I guess from your side and from the prosecutor side, they keep saying that there's no kidnapping. But under Arkansas law, though, she was a minor and there was a protective order. And whether she went and actually got in his vehicle or not.
We can't hash the case out right here. I can't.
Okay.
Like I just said, I can't discuss the case. There's a lot of what ifs and what ifs here and there. There's a protection order. But all this is going to come out in the trial in January.
Okay.
What was said on social media, they make it sound like she was kidnapped out of her house in the middle of the night, and that did not occur.
So notice at the beginning, he says that he doesn't know what source it was that outed the fact that they initially asked him about the kidnapping. But later on, you'll hear him basically say, oh, it was this individual and I know who it was. And no, there was no kidnapping. So he is standing on the fact that there was no kidnapping. Now, let's be very clear. We're not talking about someone sneaking into the home and grabbing her and pulling her out of her bed in the middle of the night and throwing her into a vehicle and things like that. We're talking about a child who had been groomed, who had been assaulted by this individual who, by the way, had 43 different felony counts against him pending, who had nothing more than a piece of paper between him and this child. Okay? Now let's look at exactly what the kidnapping statute says in Arkansas. So in Arkansas, a person commits the offense of kidnapping if without consent the person restrains another person so as to interfere substantially with the other person's liberty with the purpose of, and there's specific ones I want to look at here. 1, if we look down here at number 2, using the other person as a shield or hostage. Also, 3, facilitating the commission of any felony or flight after the felony, inflicting physical injury upon the other person, engaging in sexual intercourse, deviant sexual activity, or sexual contact with another person, terrorizing the other person, or interfering with the performance of any government or political function. She was, in fact, SA'd again that night, and last time I checked, a government or political function is a court case. I think we can reasonably assume that she was kidnapped. She was taken. She doesn't have the ability to consent because she is a child. And if Arkansas state law legitimately says that a 14-year-old can consent to leave with a predator that has felony counts legitimately pending against him, where she is the star witness in the case, then we have a serious problem, Arkansas. But let's continue. I don't think anyone has ever said that she was snatched up in the dark of the night and kidnapped. I think the fact of the matter is she was taken from her home. He physically came to the home to pick her up with his truck and to take a child that he had authority to be with. There's no care, no custody, no control, no nothing. He had a protection order saying he couldn't be around her. We just looked at the definition of kidnapping. Again, it's kidnapping. End of story. Let's continue.
Of course. We developed a factual case file and submitted to the prosecutor. But in the terms that have been shared all over the world, really, that they make it sound like this girl was snatched away in the dark of the night and kidnapped, that's all going to come out in trial, and the true, actual facts will be shared that we can't talk about. There's not a gag order, but that's why the gag order is asked for. So misconceptions and untruths and twisted facts wouldn't be shared, but they've been shared all over.
So now he's talking about the reason why a gag order was asked for. So misconceptions and truths and facts could not be shared. Well, I'm sorry, regardless of what you want to do, you cannot put a gag order on every single person in the world, which is ultimately what they did, number 1. And number 2, you cannot violate a defendant's constitutionally protected right to speak out on their own behalf in their own case. So that's the reason why it was overturned by the court. So why we're even talking about this, I don't know, but that's besides the point. Let's continue.
And the one who stands there and gets berated is me. We've just built a case file on what the facts are and submitted to the prosecutor. And if there's elements meet certain statutes,
sure,
such as murder in the second degree or murder in the first degree or manslaughter, or if it could have been justified under the statute of stand your ground, as what some people call it, or
defense of others,
self-defense, different places call it different things, then I'm sure the prosecutor would have said, yeah, that's justified.
So now he's talking about how he's the one that gets berated. He's getting berated. Well, let's be clear about something. There is a lot of stuff going around, number 1, about certain connections with this family. I would love to hear from Fosler's family, and I would love to see proof that these are not true. While he has blatantly denied a lot of this, and we'll get into this later on in the interview, he did, in fact, go to high school with Michael Fosler's daughter, Angie, number 1. And so that seems to be a conflict of interest.
Was there any body cam footage? Can you at least comment on that? Even if you can't release the body cam footage, was there body cams that were in fact worn that night? Can you answer that question?
I mean, we weren't involved in the homicide.
Of course. I mean, was there body cam footage? Like, were there body cams worn when you guys showed up to the scene was...
We do have a policy, and our policies were followed based on the body cams and the dash cams that we have. I can confirm that the policies were followed by the deputies that responded to every incident that is connected with this.
Okay.
Because this isn't just, I mean, this is also they've connected all the way back to the original incident and led to what happened here. So it's a very detailed case. The prosecutor has all the facts in the files. They're the only ones that can really make comments on it.
Of course. And of course we've reached out and you know, there's not a lot that they're obviously going to say until...
So the rules of criminal procedure in Arkansas are pretty clear about extrajudicial statements.
Correct.
By prosecutors and law enforcement. And that's what I'm just going to tell you, that's what sucks.
Yeah.
That's what sucks about people can go out here and say whatever they want about elected officials and about a case, but the true, accurate facts will come out in January in the trial. But yes, I can confirm that the deputies followed protocol and procedure throughout the case, and but all that is part of the.
Of course, it's a part of the case. No, I realize that.
You weren't there, and it's been made very clear by John Staley that they were not there during the self-defense episode, which is what I'm going to call it, because I do not believe that this is murder by any stretch of the imagination. So because nobody was there, what facts are you standing on to state that this is not self-defense? Because here's what the self-defense statute says in the state of Arkansas. A person is justified in using deadly physical force upon another person if the person reasonably believes that the other person is committing or about to commit a felony involving physical force or violence, using or about to use unlawful deadly physical force, or imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic abuse. And this has changed since 2021. A person is not required to retreat before using deadly physical force if the person is lawfully present at the location where the deadly physical force is used, has a reasonable belief that the person against whom the deadly physical force is used is imminently threatening to cause death or serious physical injury to the person or another person. Also in Arkansas, there is another statute called Choice of Evils, which says conduct that would otherwise constitute an offense is justifiable when the conduct is necessary as an emergency measure to avoid an imminent public or private injury, and according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injury sought to be prevented by the law prescribing the conduct. Justification under this section shall not rest upon a consideration pertaining to the morality or advisability of the statute defining the offense charge. If the actor is reckless or negligent in bringing about a situation requiring choice of evils, or in appraising the necessity for his or her conduct, the justification afforded by this section is unavailable in a prosecution for an offense for which recklessness or negligence, as the case may be, suffices to establish a culpable mental state. Sounds like self-defense to me. What do you guys think? Let's continue.
Very different than what because I'm the one standing here being told I'm a hero arrester, and I'm like, look, I'm just following what the law says, and I don't file charges. I report to the prosecuting attorney of what elements we found and what the elements show, what the evidence shows, and they decide if there's charges or not, and we just share that factual information. And I pray for that family all the time, and I don't know, I know that I've got 25 years in law enforcement, 13 as sheriff. I've been serving since 2013, so we're coming up on 13 years.
Yeah.
And this is we got a guy now wanting to run for sheriff while he's pending charges and who has no experience as law enforcement. And we didn't treat him wrong. We were very kind to the man, and I understand his plight. I understand it was his daughter, and it's a heartbreaking situation, but we got to have a trial to share the evidence, and I can, like I said, I can send you that video I did. Short video to make it easy and clear, so we don't mix up words or miss statements. Because I've had people calling from Australia and New Zealand and UK and New York, and I got to. There's a lot I would love to tell you.
Right.
I can't until we go to trial.
No, I understand. One other question too is, do you have any comments that you can make on the pipe that was found in the back of the SUV? It's another resounding question that we've had a lot of people ask.
So, yes, I can answer that. That was never even a charge on Mr. Spencer. There was never even a question about that. And when we have a missing kid, the deputies jump and run. There was people in the back of that patrol car before, and we do check before and after an arrest. But a lot of times stuff happens that where you have somebody back in your car, another agency's coming to pick them up because they have a warrant. They meet you, you get them out of the car, you put them in that car, then you run to another call.
Right.
And since you didn't transport, you didn't check. Or if you did, when you did check, you didn't run your hand far enough underneath the seat or whatever. And it was knocked loose while Mr. Spencer was back there moving around. And I personally got there and I got him out, got him handcuffed in front, made sure he was okay, made sure he understood his rights, told him we was going to get him out of there and get him somewhere more comfortable as soon as we could. And before he got back in the car, I let him put his shoes back on, he saw something in the floor that we didn't see. And, of course, now his story has been around and saying that I tried to put something on him. That's a misdemeanor in the state of Arkansas. We tracked down the owner of that pipe. The man admitted it, and he was charged.
Okay.
He said that he didn't want to take it to jail with him because if you take it to the jail, it's a felony.
Of course.
He was getting transferred to another agency, and so they were just waiting on him. And when he shoved it in the seat, it just got dislodged, and absolutely nobody was. It doesn't even make sense that people are trying to say it was planted because he was never charged with that. And I actually, something we never do that's a misdemeanor. It's a very low crime. So I sent him that was me that said, hey, I'll give you a drug test. You want to prove that it's not yours? I mean, we know it's not yours. We're not charging you with it. Here's a drug test. He even sent that and had to have a special test done. They thought I was crazy sending a meth pipe to a suspected meth pipe. I don't know. I'm sure it was, but we even had to do DNA and fingerprints just to ensure it wasn't his because there wasn't even a charge. The detectives, when they heard about that, this is a serious crime, homicide. So they tracked down the last two people who was in the car, and the very first one was like, hell yeah, they want to take it to jail with me.
Yeah.
And that guy's been cited. And
Gotcha.
I don't know, they just don't report that stuff. They don't want to share that stuff. They want to make it look as salacious as they can, but Mr. Spencer was treated with the utmost respect. Nobody disrespected him. Nobody wants to. It's a horrible situation. I hate that his daughter was involved in that situation. But there's a lot of facts that have been twisted, and as you stated, there was a protection order in place, no contact order. That would have been a violation of a no contact order.
Yes.
But it wasn't. They make it sound like she was kidnapped and he was running away with her.
I don't think anyone is saying that this is like what you see in the movies where he again went into the house and grabbed her out of her bed and then threw her in the back of a white van, and nobody is assuming that. But let's also look at what the court in Arkansas has already determined constitutes kidnapping, because there's a couple cases that pretty much outline exactly what is going on here. Okay, so in the first case where the defendant was accused of kidnapping and another offense, his acquittal on the other charge did not make it impossible for him to be guilty of kidnapping, since to convict him of kidnapping, it was only necessary to show that the victim was forcibly taken for the purpose of committing a felony. In the second case, where the state charged the kidnapping occurred either for the purpose of terrorizing the victim or for facilitating the commission of a felony, the jury did not have to find the kidnapping occurred in connection with the felony in order to convict the defendant for kidnapping. In the third case, evidence showing the appellate formed a plan to lure the victim into his vehicle with the purpose of injuring or killing him, and that the victim died under the circumstances manifesting extreme indifference to the value of human life, was sufficient to support appellate's conviction for capital felony murder with an underlying charge of kidnapping. Remember, she was SA'd that night. And then the fourth case, evidence was sufficient to sustain defendant's kidnapping conviction as the 13-year-old victim's mother relied upon the representation that defendant was taking the victim to the movies with his daughter when she gave permission to the victim to leave her home with the defendant. The victim's mother did not consent to the defendant escorting her daughter to a motel room under the guise of meeting someone briefly before meeting his daughter at the movies. Most closely related case. So again, I think we can reasonably assume that she was kidnapped. But what he says next had me a little concerned, because when we start blaming the victim, especially when she is a 14-year-old child, that's a problem. Listen to this. I mean, she was in again, and I get you can't speak on this, but again, and I'm not sure if you're a father or what, but again, as a parent myself, you know, it's we also have to look at the situation as like, she's 14, she can't consent, right? And I think that's what a lot of the public's, you know, mad about.
You're right, they can't consent, but I do have a 13-year-old, I have a 15-year-old, and I have a 23-year-old, all 3 daughters. And we're not talking about a small child that was kidnapped. It was these kids that age make decisions that are, you know, whether they're misled. Most of the time they are misled, but all we got was about a runaway.
Yeah, and I mean, grooming plays a lot of part in that too, you know, in terms of the mental capacity. And again, I know that you can't speak on a lot of that, but I think that's a lot of what, you know, I think the public is irate about.
Well, whenever facts are distorted and they use the word kidnapping, there's a reason the word kidnapping was used. That makes it sound like somebody was snatched away in the middle of the night to be taken away. Whenever the facts come out, you'll see that it's a whole different story. And that's all I can say right now is when the actual facts come out, it's a whole different story line than what's being shared right now. And that's all I can say.
Okay.
I can't go into the details. Sure. I would love to go into the details. The prosecutor maybe will tell you more, but when the actual facts come out, you'll be shocked to realize that, you know what, you're right. 14-year-olds can't, by law, cannot make give consent, but you know, it also doesn't mean that they're not making poor choices. And we're not putting this off on the young lady because there's a lot more to this case. But it makes it sound like, I mean, there was one statement out there from the mother that she was worried that she was being taken away and would never see her again. Well, when you get the facts, you'll see that. You'll have to see the actual facts.
So he says that he's not victim blaming, but he's literally saying 13 and 14-year-olds collectively make bad decisions. This is a child that was groomed and assaulted by a 67-year-old man. And we're going to literally claim that she made a bad decision by leaving that night? There is trauma that goes along with this. We also don't know what was said to her to get her out of that house. Only she does, and she will most likely be attesting to that at trial. So we'll find all of this out at trial, which I plan on being at. But this is wild to me. You can't literally sit here and say that she was groomed, sexually assaulted multiple times, and yet she's the one that made the bad decision by leaving that night and getting in the vehicle with him. I'm not buying it. I'm not buying it.
But
well, hopefully I can get the prosecutor, you know, to make some statements because, you know, like I said, my biggest thing is that we see there's multiple other states and jurisdictions, and I get every state's different and I understand how all that works. But there's so many other states where they're not charging individuals, right? In situations that are very eerily similar. And again, obviously, like you said,
the problem is, you say they're similar, you don't even know the facts.
Well,
all you know is one side of the story. They come from the guy who's accused.
Well, I mean, and I'm reading the affidavit that I do have from the prosecutor. So I would assume that from the probable cause affidavit that there's, you know, I am taking that into consideration as well. So just to be fair, I'm not just looking at one side.
If you have that probable cause affidavit, there's one statement in there where it says Spencer stated he saw Fosler's truck.
Yes.
To that effect?
Yes.
And he followed it back towards his house?
Yes.
That's Spencer's house, not Fosler's house.
Correct. So I'm right. He was leaving his house, and then again there was a U-turn that was made, and then he followed him back past Spencer's house, and he continued following him because his daughter was in the truck.
Yeah.
And so that's Mr. Spencer's daughter was in the truck.
You're right. But he followed that truck for 5 miles back towards his own house. Mm-hmm. He got behind it as that vehicle was traveling back towards Spencer's house.
Correct.
That's why.
But it passed.
It passed him because he was behind him, and then he was rammed off the road just a little bit past that house. So, let's say, what if he would have waited and not been on the, as he says, as Spencer says, flashing his lights and honking his horn? Does it sound to you like he might have been bringing her home, which doesn't make it right that she was with him? But think of the, at no time was 911 called either, and behind his truck, my daughter's in it. He knows we're headed to his house to take that report and try to start looking for his daughter, which is missing. That was the 911 call. That's
Sure.
where we were headed to.
Well, and again, I as a parent, I can't say that I would have done anything any different. When my child's missing, I'm going to jump into a car and go try to find them immediately, right? Like, that's going to be the first thing foremost on my mind. And so,
You already called 911 once, and you called 911 twice. What was it 911 called in the middle? I mean, that's just me as a dad thinking. That's not me as sheriff talking. I'm just saying, when you read that affidavit,
sure,
critical thinking's there too. Is hey, I'm behind the truck. Cops are coming to your house. Cops are headed the same way you're going. There may be policemen at your house.
Right.
He didn't know if we were there yet or not.
Yeah, of course. But then we got trauma involved too, right? Like, your baby's in there. You know what I mean? So again, and that's where, again, yes, the jury has to make a determination once the facts come out. You know what I mean? But just to be fair, I am looking at both sides,
I get it. What I'm saying is that was just me. I'm just saying if they don't believe you're right. So
no, I get it, and that's why when I that statement, I believe the guy's name was Coyote something, but it was a news conglomerate, like an independent news conglomerate that put this
Texas. He called and
statement out.
He asked me. He asked me. He said that they were talking about. He had also said somebody had said it was kidnapping, wasn't a kidnapping, and I can tell you that it was not a kidnapping.
Gotcha.
So, and when I say that, people make it sound like it was like a John Benet Ramsey. She wasn't kidnapped, but you know what I'm talking about.
Yeah, like a ransom note and everything.
Yeah, they thought somebody swooped in the middle of the night and picked them up out of the bed, forced them in a truck, and it wasn't. That's not what happened.
Right. No, and
should have been no contact order, but
from the feedback that I'm getting is it's the fact that she is 14 and she cannot consent, and then there's a mental component to being groomed and being and going through that and having the threats made against you after seeing the father. And again, there obviously, like you said, the info's gonna come out at trial.
What threats were made?
The threats that he was not going to take her. He was not going to take her home after seeing Aaron, and he wasn't going to let her out of the truck, and then blocking her in the truck when she tried to get out.
Who said any of that?
So, I mean, again, sources that other sources that I've spoken with. So again, that's why I wanted to speak with you guys to get again.
That right there was news to me.
So,
what you just said about threats about.
Yeah.
That's news to me. But I'll tell you, a lot of that stuff that you just said will come out that may not be quite accurate what they say on social media and these sources that don't know. Because the only ones I know that do know what happened is, of course, Eric Spencer knows what happened. And our evidence shows us what appears to have happened.
Sure.
And we haven't talked to anybody, and the only person the guy said he was a coyote, whatever, he asked me if it was a kidnapping. I said, not in the sense of, like, we just talked about, no, it was not a kidnapping in the sense of somebody swooped in the middle of the night and, kids, took you at gunpoint or something. Nobody kidnapped somebody.
Sure. And I haven't heard that definition of it by any stretch of the imagination. Like I said, I think the thought process in terms of kidnapping is she's 14, she can't consent, and then she was also, she was, violated by him again that evening, which, again, I have seen that confirmation as well from another source. So, again, a lot of this stuff I know is going to come out at trial.
Sure.
So,
a lot of sources may not be accurate.
well,
A lot of them can be, so.
yeah, again, I think a medical report is pretty accurate. But again, we'll see what happens. But that's why I wanted to give you guys an opportunity, you know what I mean, to kind of tell your side of everything as well. So, did you personally know the Fosler family? There's some stuff saying that I guess you and maybe his daughter had gone to high school together, and there was some personal connection.
We graduated high school at Cabot High School, and there was 497, almost 500 kids graduated from that school.
Okay.
But as sheriff, you come to know a lot of folks, and I've seen all kinds of things on there. No, I knew him just about as well as I did Aaron Spencer's. Hey, how are you doing? I seen that he went to the schools. They're both in the military. As being sheriff over the years, you get to know a little bit about everybody, and a lot of people know you better than you know them. But we learned a lot more about. I didn't know he was a policeman until they started saying that we covered because he's a policeman. Well, he was pending those numerous charges. There was no favoritism showed towards that guy. He was arrested by Cabot Police Department. We took the initial call, ordered to Cabot because that's where it appeared at their jurisdiction. They're in our county.
Okay.
He was arrested.
Made the arrest on that case. Okay.
We took the initial report by a mandated reporter, and we went to that house and we said, "Hey, this is what we've got," and we were almost turned away, and we talked to him to let us investigate, and we found out that Cabot, it happened in Cabot, so we turned it over to Cabot Police Department, and Cabot investigated, and it was rather quick. They got an affidavit and a warrant. They arrested him. They brought him to the county jail, which I run. He was booked in just like everybody else. He was in jail for 7 or 8 days. You got to look at the calendar, look at the time on the calendar. I think it was 8 days, 8 dates. And we had talked to the only people he had was his 2 daughters. That's how I know he has 2 daughters. And I've known him through the years of, hey, how are you doing? When you're the sheriff and you pull 80% of the vote through most of your elections, you get to know the majority of the people.
Sure.
John Staley's not a pedophile, but he had an affair with one of his daughters, which that's crazy. So.
Did you guys ever date in high school? Because we did see that, and that's a lot of the reason why I wanted to kind of clarify.
No, absolutely not. No, I don't even know where they come from. I don't know where people come up with about 90% of the stuff they come up with. No, we were never in a dating relationship. Never anything close to that. It's we have daughters that are about the same age that went to school together.
Sure. Okay. What's shocking to a lot of people is that his was $50,000 for 43 felony counts, and again, we'll obviously reach out to, and attempt to reach out to the prosecutor again and the judge, but that's $50,000. But then Aaron Spencer, who only had one charge with an enhancement, was $150,000, so he's $15,000, and someone with those 43 felony counts, and I think that's where a lot of the the information or the speculation is coming into play.
You got to look at what classification felonies they are. What classification felonies? I don't know about. You're in Texas, right?
I'm Texas and Missouri. Yep.
SWAT felony, which is rape, homicide. So Foster had a class Y felony, I believe, was a rape.
So
I don't know what the original charges were.
Yeah.
Because I don't have it in front of me, but you got to look at the what happened, and what happened was they looked at the affidavits. Look, I think that you're going to get John's personal opinion. I hold sex offenders and sexual predators accountable every day. Every year this time, that's what we're doing today. Every year this time of year, right before Halloween, we work with parole and probation, and we go knock on every sex offender's door. Every sex offender. And we go, and especially the ones on parole. The ones on parole or today, we go and we check everyone out of a search waiver just to make sure they don't have anything. And I'm more worried about the ones we don't know about than the ones that are watched like we're watching them, but we do that.
Of course.
We've always done that. They used to come to the sheriff's office, but the parole probation stopped, that they can't make them come to the sheriff's office. We used to make them come up here and watch the news or watch a movie that was chosen by the parole officer. So there's just so many things that we've done over the last 10 years that absolutely do I think the bond could have been higher? Yeah. But to make sure they appear in court. I can't answer for the bonds because I'm not the judge.
Sure, absolutely. Yeah, so it looks like there was multiple counts of internet stalking of a child, and then the SA or sexual assault 4th degree, sexual indecency with a child, and then electronic facilitation of child sexual abuse, pandering or possessing of, CSAM material, multiple charges of those.
Those charges there are internet stalking is where he was talking to her over the internet, which could have been any kind of social media.
Right.
Whether it could be text messages. It's probably a social media. And the other ones were probably pictures and, CSAM's pictures. Mm-hmm. Shared pictures probably. Again, I don't know the case.
Of course.
But the different classifications of felonies, it's 4th degree sexual assault. So I don't know that they had a rape charge on it. That's what one of the original charges looked to be. But it could have been sexual assault, which to me, there's no difference. I mean, it's horrible. I got $3.
Yeah, because it looks like Arkansas is one of the only states, which actually surprises me, that Arkansas is one of the few states that if the child is 14, whereas when this first happened, she was 13, but once they hit 14, then it drops down to sexual indecency with a minor instead of a more serious felony offense, which is crazy to me. But again,
to let you know this, I work with the legislature. We talk to senators. I'm the president of our Sheriff Association. That's where a lot of people are slamming me, but I work from this every day. You got a case where a young lady come down from Wisconsin, and a man was in Austin, Arkansas. We went with the Austin Police Department. Parole went by there to check on the guy. He was on parole. He had went all the way to Wisconsin, and they had researched the laws. He's in jail now. We tracked him with the FBI. What is his name? The one, Gary Day. Gary Day. We tracked him, worked with the FBI, and that's why they come back to Arkansas. We've got to change the laws in Arkansas.
Yeah.
I support changing the laws in Arkansas. I told our senators we need to change it. It needs to be 18 years old for consent. But right now, you can be 14 years old and give consent, 16 years old.
Yeah.
And that is absolutely crazy to me that my 14-year-old can't smoke a cigarette. I don't want her to. I'm against that.
But I get what you're saying, yeah.
But they can, we moved that to 21, but they can go out and have sex? Absolutely not. I don't agree with that.
Especially with adults, not even just other, children or 18-year-olds. I mean, in this case, we're talking about a 67-year-old, which is just wild to me.
Absolutely. It's wild to me as well. And that's what I could talk to anybody about that stuff. They want to go into the Aaron Spencer case. Well,
sure.
Do I blame Aaron Spencer for what he did? Aaron Spencer is being held accountable based on what the law says. It doesn't matter what my emotions are. I can't have emotions towards this.
Sure.
I just can't.
Sure.
And then I'm judged based on that I'm the judge, jury, and executioner, when in fact we just did our job. Then I'm accused of dropping a dope pipe. See,
another thing that I read online was that you have the option on whether or not you want to arrest somebody, or you want to just hand it over to the prosecutor to make that determination. And you guys made the determination to arrest him on 1st degree, presented as such, and then.
Thank you. So let me clarify that.
Sure.
We don't have an option to arrest when it's a major felony. We're on the phone on a major crime scene. We communicate directly with the prosecutor. Like if there's a death, there's certain people that have to be notified of any death that happens in the county. And the sheriff's one, and the prosecutor's the other. And as we notify the prosecutor that we have we go through the elements of what we see.
Sure.
And what the evidence shows. The prosecutor says, all right, the initial charge will be capital murder, first degree murder, second degree murder, manslaughter. But do we have discretion? On lower level crimes, we have discretion. In that situation there, as we're communicating with the prosecutor, there's a dead person there. We had a case a couple of years ago where the lady was called 911 and a guy was trying to get in her house. Banging on the door. Well, he had a weapon in his hand, a long rifle. Well, as soon as that door came open, she shot and killed him right there in her doorway. We arrive on scene, start talking to the prosecutor. The elements didn't meet. The elements were very clearly, they met homicide, and we had to find out if it's justified. And it very clearly was justified, but she still came to the sheriff's office and was interviewed. And she could have, said, no, I don't want to be interviewed.
But she cooperated, and so...
She cooperated and was released with no charges because the guy was laying in her doorway, forced his way in her house.
Gotcha.
That's very clear.
Do you feel that there's a difference between that situation and the Aaron Spencer situation? Just from your perspective. Again, I'm not talking about the case. I'm talking about as the law in Arkansas.
I can tell you that with the law in Arkansas, there's a very big difference.
Okay.
And I can't get into details of the case.
I get it.
Big difference.
Yeah, and that's what I'm saying.
I would not have arrested Aaron Spencer if what is out there, that there was a kidnapping, somebody was taken in the middle of the night against their will, and this happened the way it's portrayed, the prosecutor would have been like, yeah, that's justified.
We just finished the 5-part series interview with John Staley, the current Lonoke County Sheriff. I'm going to recap all of the information that we learned in here, summarize the law, and I want to know what you guys think below. So, it's about a reasonable belief on the part of the person who takes the action to protect another or himself. We've looked at the self-defense statute already. How many people do you think have a statute book readily available in that type of an emergency situation? I mean, and how many people would think that it's not technically kidnapping when a man who has committed over 43 felonies against your child and has a no contact order in place carries her away to have sex with her, which unfortunately is a Class D felony in Arkansas? I will say that all of this has caused me to look at the Arkansas S crimes and kidnapping statutes from a completely different perspective. And they are absolutely unequivocally appalling as they are applying to children 14 years of age and older who are victimized by an adult that is not a caretaker or in some position of authority over them or similar. Now, when the child was 13 over the summer, all of this behavior was subject to all kinds of Y, A, and B felony statutes, i.e. rape, SA, etc. But then once she hit the age of 14, if the offender is not in a position of trust, authority, etc., it drops down to sexual indecency with a minor under 514.110. Even the new grooming statutes, 527.307, is limited to under 14. So it would be internet stalking, though, and that is a Y felony. And to my shock, it seems that the violation of the no contact order is only an A misdemeanor. As for kidnapping, same thing. Apparently a child that is age 14 can consent to going with an adult even if the purpose is that the adult is going to commit a crime against the child. If force, threat, or deception is used, that age requirement does not apply. Now, if it is in fact true, as we have been told by multiple sources, that Fosler would not let her out of the vehicle and said, I'm not going to take you home now that your dad is basically behind us following us, then kidnapping would in fact apply. But that would have to be the case in order for that to happen, which is scary. Now, again, I did show you in the previous video the actual kidnapping precedent that has been created in Arkansas already, where a mother allowed another parent to take their daughter to the movies with their child, but because he stopped at a motel room to meet somebody else prior to taking the daughter to the movies, that was in fact considered kidnapping. So I think that there's a slippery slope, and that a jury could definitely either jury nullify something as far as this case goes, or could determine that, yes, this is in fact kidnapping because there was a no contact statute in place and the parents did not give an express permission for the child to go, obviously with a 67-year-old man who she was the star witness in his 43 felony count case, who literally took her from the home for the purpose of essaying her. I do not believe that he was taking her home. I believe that he turned around, freaked out when he saw Aaron Spencer, and then continued. Because if he was going to take the child home, why in the world did he not stop? Why did he not stop at the house? Why didn't he even just literally slow down and go, jump out of the car, get out of my car? Anything other than continuously keep driving just because Aaron Spencer was behind him, because very obviously he just wanted his child back. I do not believe Aaron Spencer went with the intention to unalive Fosler at all. I do believe that he was charged by Fosler, that he refused to allow the daughter to get out of the vehicle, and that is the specific reason why this happened. Staley is basically saying in the previous recording, and then kind of reiterating here, that Fosler was on his way to take the child home after having sex with her. Maybe he was, maybe he wasn't. But what is in fact certain is that neither Aaron Spencer or his wife, nor any other rational parent, would see Fosler with the child in his truck and think, I'll go on home and see if he brings her home. And certainly once Aaron sees them, Fosler is not going to take her home. I personally would have thought he might have been on his way to harm my family or take her away forever, since he was facing life in prison for the crimes already committed against her. Fosler clearly had a solid motivation to persuade her or prevent her in whatever ways he could not to testify against him. And the whole this is not kidnapping, right? And talking about decisions of a 14-year-old who was groomed by a pedophile, by the way. Staley is trying to normalize the relationship between a child victim and her abuser. He's trying to portray the relationship as consensual, as if that possibility even really exists. As if a child who is groomed or psychologically manipulated can really consent. He's blaming the victim pure and simple. He also clearly lacks an understanding of child crimes, right? Pedophiles and child victimology, and of AR self-defense law. Arkansas self-defense law is very, very clear. And I think it's pretty important stuff for a sheriff to know, in my personal opinion. I wanted to give him the ability to answer these questions. I think it's incredibly important that he got the ability to answer these questions. But the answers that I got, I'm not satisfied. I'm actually kind of shocked that that's the hill that both him and the prosecutor want to die on. The other weird thing that happened was Fosler actually quitclaimed his house to his daughter in September. It's public record. And I have information, which I can't confirm yet. I'm still digging into this. But I have information that he withdrew a large sum of money weeks before he was unalived by Aaron. And I'd love more information on that. So if anybody out there has any information on this, please reach out to me. Because I'm wondering why he would take out a substantial amount of money. His next court date was not until December. He also wants to sit there, meaning Staley wants to sit there and claim that he has no role in the charges. Well, he definitely could have declined to arrest and let the prosecutor charge it. He certainly can determine that there's no probable cause because the shooting appears justified. It happens very often that in the investigating agency actually determines after investigation that there's no probable cause for arrest. It happens all the time. And he just got done saying specifically that there was another woman who had a similar situation happen where she opened the door and somebody was standing there with a gun. Was the gun pointed at her? Did she feel threatened? What would a reasonable person do in that situation? Well, I think we can reasonably assume that a reasonable person in Aaron Spencer's position would have done the same thing that he did, therefore making it justified. Also, it's really important that we look at this because officers who shoot individuals are almost never, ever charged. And it's because the prosecutor or the grand jury later determines that the charges are warranted, so they file them and then arrest the cop. Instead, the sheriff arrested Aaron on probable cause for first-degree murder. First-degree murder. I wonder what the cops would have said if or what Staley, I guess, would say if the cops had seen Fosler and the child in the truck and Fosler would not stop. They ended up face to face while the child was still in the truck and Fosler exited in an aggressive manner. Do you think the cops would have hesitated to use deadly force? Absolutely not. Do you think they would have been charged? Absolutely not. Do you think there would have been any pushback? Hell no. They would be considered heroes, and in my opinion, it would be used by Staley in his upcoming re-election that he saved a child from her rapist and then got reelected. That's my opinion on that. He also continues to complain about Aaron not calling 911 and suggesting that Aaron was acting as a quote-unquote vigilante. The whole vigilante thing makes me crazy. A vigilante would have unalived Fosler outside of a situation in which Fosler presented an imminent threat of harm in that moment. Heather called the police frantic when they realized that the child was not in her bed. As Aaron prepared to get in the car before leaving and told them that she learned that her child might in fact be with Fosler, she was terrified. I'm not sure how calling the police again would have changed the situation. Like, were they taking their time in responding but would have picked up the pace if they learned that Aaron had actually found Fosler with the child? And did they expect that he would let them know, like, hey, I found this rapist pedophile with my child who's charged with having sexually abused. They took a left on Highway 13. I hope you can find them. And then head home to hope for the best, crossing our fingers? I just don't know any parent who would do that. It's insane to even suggest it, in my personal opinion. Make sure that you like, make sure that you follow. Comment your thoughts below. What did you think of this interview series? What do you think of the prosecution and Sheriff John Staley's position regarding Aaron Spencer and his case, including all of the things that were said about Michael Fosler as well? Love you guys, mean it.